Well, thanks for joining us today. I'm going to hand it over to Dan Gallatin with Miller and Stevens. We're excited to hear about his presentation.
Great, thank you very much. Dan Gallatin, I'm an attorney at Miller and Stevens. We are a 3-person law firm in Wyoming, Minnesota, just up 61 by the Nesting Grounds Cafe. I think people probably, and they're probably thankful, make more stops for coffee than to see the lawyers, but maybe sometime we can put the two of them together. Our law firm has a practice that is, I think, quite broad for the 3 attorneys there. We do primarily estate planning, business counseling, and civil litigation. So broad areas. Included sort of within that, business counseling is business formation and helping businesses as they go along in their day-to-day lives and as unfortunately may sometimes arise, their day-to-day problems. Today's presentation is tailored generally to employment law. This is the second time that I've had the good fortune of speaking at the Chamber Luncheon on employment law. We're not going to cover any of the same information as we did in the past. We'll cover hopefully topics that are of interest and that help you stay awake while you're eating lunch at least. It's important to keep in mind that the information we're going to present is a blend of state and federal law. Not every state law applies to every employer. Not every federal law applies to every employer. Some state laws and some federal laws do apply to all employers. The point being that the information today is informational in its form and in this presentation. I can't guarantee you that any information that we give today specifically applies to any given scenario you have. But hopefully you'll learn a little something while we're here. Maybe we have a little fun. And certainly we'll make it through an hour. If at any point you have any questions, I say you feel free to offer up and we'll try and address it. And if we can address it, great. And if not, we'll make sure that we address it later. So with that, any questions at the outset? All right. The general presentation is we'll run through some slides. You do have the slides in front of you. We'll pretty much just work from the slides in a couple of spots. We'll identify some cases that have come out relatively recently that Ben Stevens of our office will address. And with that, we're off. These, as it's captured in Minnesota, these are specific provisions of Minnesota law that are specific to the state of Minnesota. So if you have an office in Wisconsin or whatnot, these titles here will not, by their terms, apply to what you have. But conceptually, just appreciate there's a lot of different laws. And a lot of different ones that you maybe never heard of, and maybe you never heard of them because they would never apply to you. But be aware that there might be some real niche regulations to be aware of. Here are some of the titles that are covered or enacted as federal regulations. And a lot of these you probably are familiar with. The Americans with Disabilities Act, the ADA. Everybody should know that title, and everybody should know at least the key provisions of that regulation. Fair Labor Standards Act, again, something that everybody should at least have a rudimentary knowledge of and make sure that you have at least the basics in place for your workplace. Mining Safety Act, I'd be shocked if anybody here had any idea about any clause of the Mining Safety Act. But if we're in West Virginia, different story. Family and Medical Leave Act, again, something that pretty much everybody should have at least some working knowledge of. And really, if you don't, then as a lawyer, I'm really happy to hear that because you're going to come into a big problem really fast, and then maybe you're calling us. Preferentially, though, you do have some working knowledge of it, and it is something you've incorporated into your business existence, and you're making sure you stay on top of. So when do federal regulations apply versus Minnesota law? And again, sometimes it's both, sometimes it's only one or the other. This slide just gives the general big picture rules on when you should be paying attention to one more specifically than the other. And really it's just sort of broken out into the concept of how big are you? All right, the feds are more concerned with you on a real tight sort of basis compared to the state to a real degree. So there are two types of employment that you have for your employees. The first that we'll talk about is at-will employment. And what it means most fundamentally is the employee's tenure as an employee is not guaranteed beyond any point in time. The employee is terminable at any point in time. On the other hand, what you'd have is an employment agreement, a contractual basis between the employer and the employee that identifies a guaranteed period of employment with some degree of guaranteed terms. The difference, of course, at will you can terminate right away. Contract, you have this ongoing obligation, but almost certainly you also have additional mandated obligations beyond a term of employment. Almost all of your employment agreements are going to have some provisions that identify compensation rates or schedules or reviews of something of that sort. At-will employment only speaks to the term of employment, okay? A very important difference. You might think you have all employees at will because you don't have a written employment agreement, and that would be a misperception, okay? Employment agreements and employment contracts can be formed by your verbal representations or assurances as an employer, okay? It's a very fact-specific scenario, but it's something that all employers need to be aware of, okay? Just because you don't have something in writing doesn't mean you don't have an enforceable employment agreement, all right? If we look here at the fourth bullet point, we identify a best practice for employers, okay? Clearly identified in your employees' employment is at will. You can expressly identify that in a written employment contract or letter of engagement, okay? You can identify that the employee's employment is strictly at will and that nothing done or said to the contrary changes the employment at will. All right? Any questions about that idea? Again, it's a very fact-specific thing about what you do or don't do to create an employment contract. Just be aware that employment at will, for the employer's perspective, is generally preferred. Because if you have a bad employee, you want to be able to fire them. And employment at will facilitates that. Employee training. If you look at the first bullet point, it may come as a surprise, but it shouldn't be a shock either. You're not required to train any given employee, okay? If you want to take the risk of just hiring someone and throwing them into the fire and saying good luck, that's your problem, okay? On its face, of course, providing training is only beneficial to you because hopefully you get a better and more productive employee. What's important, though, is in the employment context, if you have an employer-employee relationship that goes bad, how do you as an employer minimize your exposure to that employee? And that's where training comes into play over and above the job functions. What would be best case scenario is that you as an employer have a tailored employment manual and guidelines that you can have an HR person or your owner, whatever, depending on the size of your organization, But you have somebody who can sit down with the new employee and you walk through some of these, if not all, of these next 6 bullets that are on the slide. Because these are the things at those 6 bullet points that later on in your employment relationship with your employee can really save you a lot of problems. I think for the purpose of this presentation, I would really focus you on the essential functions because of this. If an employee fails in their essential functions, that can be a grounds for termination for cause, which keeps the employer from being exposed to unemployment claims. All right. On the other side, I guess if you're the employee, you do want to know for sure what your essential job functions are so that you make sure you fulfill them. So that if you are terminated, your termination is not on a for cause basis because you failed to do your job. Sexual harassment standards, obviously extremely important for the purpose of the employer, making sure that the employees within the workplace understand that it's not acceptable for one, and two, that the company specifically has a policy in place prohibiting it. Okay? It will not necessarily fully insulate you as an employer from a lawsuit, but it can be helpful if you identify that all the employees are trained on this specific sexual harassment standard, and that standard's revisited on hopefully an annual basis, and that termination in a sexual harassment concept is not new or shouldn't be a surprise to the employee based on your internal employer actions and trainings. If you look at discrimination standards, I don't have an expectation that all of your employees are going to know or be rigorously educated on discrimination standards. Really what you're looking at with that, from my perspective, is on your supervisors, on your trainers, on your hirers. They're the ones that really know what they can and can't do when it comes to job placements and your hiring practices. And then as far as disciplinary procedures, that is one that I think employees should be aware that they exist. The importance of disciplinary procedures is on the employer side, in that employers should have a fair and advertised, at least internally, disciplinary procedure that they follow when they're handling employees. Because it can be a very good saving grace to the employer if they can identify the procedures that exist internally and that were actually followed in the termination of an employee for potential post-termination claims. Go ahead.
I just want to amplify what Dan had said about the managers being well-versed in the discrimination practices or standards. And that is because what might be obvious to most of us, discriminating based on race or gender, we all know not to do that, but there are wide categories. In fact, I had a case in which my client was discriminated against because he had diabetes. Some of us may not realize that that's a protected class, and that case was later settled. So the managers and supervisors should know the discrimination standards quite well. It's not just the obvious ones.
Here was mentioned a couple of minutes ago, every employer really should have, to some degree or another, an employee manual or a training book. Now, I won't say that it makes sense that if you're a 5-employee business that you have a 75-page employment manual. I don't think that makes sense. And it actually, I think, creates a significant risk for the employer because you may have a lot more detail and depth than you really appreciate or use in your business, and you may end up waiving provisions of your employment manual that just maybe you didn't even understand existed or might apply. But if you get a aggrieved employee who gets a lawyer who starts really combing through your 75 pages and identifies you didn't comply with page 7, 14, 15, and 19 through 26, well, now the significance of you doing it right as far as what's on page 4 can be minimized.
where the plaintiff's lawyer will begin and actually have some good ammunition for argument that you've waived the provisions of your employment manual by virtue of the disregard and noncompliance with your own manual. So what you thought was a safety net really turns into a nothing. So big employers, yeah, makes good sense. You've got a more complex organization, you have more things going on, more protocol. But that gets back then to your manager sort of level. Your manager level, the people who will actually be sort of enforcing your manual on a day-to-day basis, they need to be well versed in what your employee book says to make sure that they are following your own manual. It's just a tailoring to the complexity and size of your organization, but incredibly important over the scope of all sizes of employers. All right. This is something quite basic, quite straightforward by its terms. Harassment. We all understand the general concept of what harassment is. I think we can all appreciate that in general, harassment doesn't have a place in the workplace. You don't want that as an employer. You don't want that as an employee. What you have to really be careful about, though, is within the context of your employer situation, is what constitutes a harassment. Without generalizing, I think that what you can get away with at the auto body shop is not the same as what you can get away with in the junior high classroom. Okay? There's a little different protocol that exists to a real degree in those two places. It's important that for your employment, your employees understand what's acceptable or not acceptable. And if something falls outside the realm of what you as an employer consider acceptable, then it's got to be addressed in a very, very timely manner. I think if you look at this bullet point here, harassment outside of the workplace may also be illegal if there is a link to the workplace. Okay? It's perhaps unfair in a sense, but it's certainly the truth that employment harassment doesn't only happen within the 8 to 4:30 workday. Okay? If you have employer-sponsored functions, if you have employer-mandated trainings or whatnot that are either outside the office or outside the standard workday, activity within those events can be related back to your workplace. Okay? Even something extremely simple as work phone to work phone outside of the actual employment day may be enough, depending on the context, to get the employer into a spot where they're facing a harassment claim. So obviously extremely difficult to corral. I mean, you can't be monitoring everyone all the time, but the educational front that you provide to your employees may help you curb their own conduct and then the problems that you face in a later date.
And pay attention to what your subordinates are doing. I mean, I know everybody here, nobody here would be engaging in harassment, but pay attention. A lot of, when owners get in trouble, it's because they're not looking, they're not watching and seeing what's going on in the workplace. Either they're absent from the workplace, or they're just not, they don't want to get into it with their subordinates or employees. But pay attention, because that, if there is harassment going on, they're the ones that are going to bear the punishment.
All right. Obviously, with the amount of bullets on this one, we could take almost the entire hour to address it. We won't do that. But I just suggest that you pay attention to this slide so that, I think maybe Birchwood, I think some of you are in the HR side of things, but just know as an employer what you're required to track. And you don't want to get caught in a spot where you're facing a wage and hour claim and the employee says, hey, I worked an extra 15 minutes every single day. And they hire a lawyer. The lawyer says, all right, give me your timesheets. We know you have to have them. You know you have to have them. Let me see your record of their time. If you're caught, looking around saying, oops, my fault, well, there goes a significant element of your defense. Okay? And then same side really for an employee, that if you don't want to get caught in a spot where your employer is pushing you, hey, give me another 15, give me another 20, and I'll make it up to you later. Well, your employee timesheet is your best documentation for identifying. No, I'm not just saying I did an extra 20 minutes a day, 3 days a week. Look at my timesheet. The timesheet identifies it. The document is the best evidence that you can have at a later date, and it's also required. So pay attention to that slide as you see fit. No need to really cover it in further depth, I think, right now. Okay. This slide here really tracks back to your Americans with Disabilities Act without identifying that by title. Reasonable accommodations must be made to facilitate an employee's employment. Now, reasonable is probably a lawyer's favorite word because it has no good meaning. To be realistic, what's reasonable to me is probably or maybe not reasonable to Vince or any other table. And the case law identifies what's reasonable really is within the context of the employer specifically. And one of the predominant factors as far as the reasonableness of an accommodation is the monetary impact on an employer. If you're an employer with $100,000 of annual revenue and the accommodation necessary to facilitate an employment is going to cost you $50,000, there's a very, very good basis on the employer side that it would not be a reasonable accommodation in that employer context. Okay, it's not the only variable, but employers have asserted defenses successfully that it's cost prohibitive to provide an accommodation and that's taken out of the reasonable context, which really in some degree seems to be an unreasonable application because the purpose of this is to be able to provide an otherwise capable employee with employment. So it's sort of a pro-employee provision, but which is you're employed for the compensation. But the courts are, at least in this context, to a degree sympathetic with employers on the financial impact on them for a reasonable accommodation. All right. This question has come up before and does with some degree of regularity. A physical exam. Can you require a physical exam as a condition of employment? And there's nothing that really prohibits it. You are allowed to do that. The employer, like with some of these other things we'll see, the employer cannot just sort of figure out that, hey, Dan might look like he otherwise fits and he's probably the best candidate, but what I don't want to have happen is him get hired. So I need to figure out a way to keep Dan from getting hired. And he's 5'11", he's a little overweight. I think what I'm going to do is require that he's able to slam dunk a basketball to work for me at the print shop. Okay? That's the physical exam. All right, Dan, you pass that, you go slam dunk the basketball and you're hired. No, you can't do that. Obviously in the Constitution, it's a completely irrational example, but the point to be had is you can't just sort of pick and choose and tailor your physical exam to further an inappropriate employment decision, okay? If you're going to identify that you as an employer need some physical requirements for your job, identify as objectively as you can in writing what the physical requirements are and ensure that your physical exam is in some very, very good way related to those physical requirements. In that sort of a situation, yeah, perfectly reasonable that you go ahead and get some sort of a physical exam. Yeah.
Is that the case where during the interview, should you explain to them the job description and what's the requirements of it? And ask the question, do you have any issue with that? Or is that against some rules? Is it during the interview process that you could do that? Or do you have to make a job offer and then rule them out as a candidate after that job offer's been made?
All right. In case everyone didn't hear, the question essentially is, at what point in the hiring process do you disclose that there will be a physical exam required for the employment?
Or even just that there's physical attributes to the position. Whether you're standing on your feet for 12 hours or, lifting something or whatever.
Well, you're never going to be hurt by including that as part of your advertisement. that there are physical needs for this job, a physical examination will be required. All right. Not necessary that you do it in initial advertising, but certainly if you're at an interview process, yes, identify at that point that a condition of employment is the passing of a physical exam. And at the very least, and absolutely, before any employment offer is made, they need to understand a condition of employment, initial employment even, is the passing of a physical exam. And then the candidate always does have the option to opt out for no rhyme or reason. They just say, thank you, but I'm no longer interested in the job. And that's fair. That's your best, safest way to go about it. Okay. Drug testing. This one comes up on occasion as well, but consistent with the physical exam requirement, don't just pick and choose who you put in for the drug test. I mean, if I come in, and my eyes are bloodshot and jaundiced, don't say, hey, I think this one needs one. I think we better get a test on this. Just do it consistently. Okay. We're going to start to shift gears a little bit into what's really exploding in a real sense in the employment litigation world, and that's in the wage and hour claims. There are, both on the state and the federal side, some very detailed and strict regulations about an employee's workday. How many hours you can make them work, the breaks you have to allow, and that sort of thing. And although it seems, you understand your employee's workday is, 7 to 3:30, some of the things that you may identify within the scope of this may be news to you, and certainly is a refresher to you, because some very small things have led to some very significant claims against employers in the wage and hour context. So specific to this slide here, as far as what Minnesota law requires. All right, 20 minutes minimum as a break, okay? 20 minutes. Put that as your watermark and set that in. Meal breaks, your 30 or 45, whatever hour you give them in the middle of the day, you don't have to compensate them for that, okay? Those two things. Keep those two things in mind most fundamentally. Then what we're going to do is we're just going to shift the gear like I suggested at the start here. Before we move to this topic of workers' compensation, as much as those things are simple, okay, as far as what your workday is, what your minimum breaks are, we're just going to have one example here of a relatively recent federal case venued in Minnesota that hopefully is of interest and shed some light on what employers face as risks in these sorts of contexts.
There's a current case that's pending in federal district court, and many of these cases are brought in federal court because the laws that are applied are federal, and the plaintiffs choose between state or federal. For the larger employers, you'll often see them in federal court. In this case, the plaintiffs have alleged that they performed unpaid work before and after their shift. They were required to don and doff protective gear. In other words, put it on and off. And this oftentimes took up to 15 minutes per day per employee prior to starting their shift and after their shift. Moreover, the employer would consider their time either when they started, when they clocked in, or when their time was supposed to start to the employer's advantage. So if you had started early, you wouldn't technically get paid until your shift started, but if you clocked in late, that's when you would be considered started. So the plaintiffs allege that this resulted in an average of 15 minutes per day of unpaid time. The court agreed to the extent that the employer's motion to dismiss was denied. In other words, the judge is letting the case go forward. It's, like I said, it's still pending. The plaintiffs were certified for a class action, meaning that all the plaintiffs can bring this lawsuit together. So these are careful reminders to follow the wage and hour requirements very carefully, because a violation of that could, if you're a large employer, could result in a class action suit, could end up in federal court. So just be very mindful of what your employees are doing before and after their shift to know if you need to compensate them for that. In this case, it was putting protective gear on and off. In your case, it might be something different, but just know if they're required to do it and it's part of the job description, it must be paid.
So I don't think that any employer here necessarily expects that they're going to face a problem in federal court over something like uniforms being put on or not, but neither did the food processing plant in St. James, Minnesota. Just something to be aware of. So, workers' compensation insurance. Everybody knows you have to have it, okay? There's really, I think, nothing shocking about that. What may be a surprise, though, is if you don't keep it up, if you don't track internally about your renewals or whatnot, and you come into the unfortunate consequence of a claim, here are some of the penalties that you can have imposed on you, okay? And then also of information value from this, if you're an employee who comes into a spot where you get hurt on the job, and unbeknownst to you, your employer didn't have the workers' compensation insurance, there's a state fund, okay? The employee is not just left out there to fend for themselves. The state's workers' compensation fund will step in. So a good safeguard for employees. If you come across someone who is in that unfortunate circumstance, maybe good information, let them know. There's a state side that will help you out. All right. The workers' compensation claim process is very, very detailed and regulated. And one of the first things you need to pay attention to, not on the slide, but is your insurance agent, okay? Your insurance agent should be a very, very good resource for you in helping you proceed through your claims process. What you need to understand, at least initially here, is that from the date of injury, you have 10 days to complete, and this is a very specific term, the first report of injury form, okay? This isn't just a form where you kind of take some notes and you kind of get an idea what happened. There's a specific form for you to use. And then if the employee is out of work for more than the 3 days because of that injury, you have to turn the form over to the state. That tracks the information within there. Look at bullet point 2. Keep in mind, this is a must. This isn't an option or make available type of a protocol. This is a must. You must give the employee, and there you see the Minnesota Workers' Compensation System Employee Information Sheet. And that is a sheet that gives the employee the information that the employee will need to further his or her workers' compensation claim. Minnesota takes this very, very seriously, and it's a very, very good employee protection that employers don't want to mess around with. All right. Yes?
Is that a form that should be filled out by the injured employee or the director over that employee with the employee present? Which would be the best way to fill that form out?
The best circumstances for the employee to provide as much of the information as possible. Okay. Because they're the one it happened to. You want to make sure you get an accurate summation of what happened.
You want a manager along with them at the same time, so they can help them fill it out, but not tell them what to fill out, but work them through the form because they've probably never seen the form before.
Yeah.
Like with young employees.
I think that's a very good insight in an employer protection side is have someone of the manager style working with the employee while the employee fills it out for the purpose of making sure that the employee is accurate about what information is filled in and that the employee does understand what he or she needs to identify. The best information only helps all the sides, and having someone a little more sophisticated within the organization will help that to cause to be happen. All right. The workers' compensation litigation side of things, that's another entire hour or more. We're not going to cover that, but if you're in contact with your insurance agent or adjuster and there's a workers' comp claim that delves into a litigation, my expectation is your work comp carrier is going to retain defense counsel for you, and you won't need to bother with that. So we'll let that go. All right. Payment of wages. It's unlikely, I think, that really many employers are paying on a once per month basis. But if it makes sense in sort of a business strategy or something in that perspective, you have the option. The only mandate is that at least once on the every 31 days, the employees get paid. Okay? I don't think your employees will like it very well if you do it that way. I know some large-scale beverage distributor does pay once a month, and I know their employees are often hungry on the last 3 days of the pay period because they don't balance their money. But that's their problem if you're from the employer side. Wage and hour. So we talked about the suit that's out and pending, but let's look at what may be the consequence to the employer if this thing goes awry. A fine of $10,000, and maybe news to you, you can go to prison as the employer for violating employment law. It's not going to be a situation where the first time you break a small law, you're going to prison, but if you're essentially a chronic offender, you can go to prison. What the plaintiff's lawyers really, really like about the whole concept is really sort of this last half of the slide, and it's really what's the problem for employers. You start getting into paying what was started out as maybe a $12 an hour situation, you end up paying around $50 an hour, not just for one employee, but for all of your employees. And it's not that all the employees have to prove their case. You get one employee in who gains a class certification. Now, every employee who's been in that job or a similar job or had the same sort of obligations, like with this case, to put on protective uniforms. Now, all the employees over the course of time who had that job and who you did the same activities with can fall within the scope of the class. And all of those past employees may then be entitled to some additional compensation. So you might think you're saving 15 minutes of time by having to put their uniforms on ahead of their workday, but the backside, the risk that you're creating for yourself is extraordinary. This slide here is somewhat of a technical slide, and if you're working with a payroll service of some sort, they should be accounting for this for you, so to speak, and making sure that you're complying with it. Make note of the slide. I would check what you're doing for your pay stubs and make sure that what you have on your pay stubs comports with what's required of you. All right. Unfortunately, or maybe fortunately, sometimes the employment is going to end. And you might think that once you've terminated employment, you're done with the problem, but the fact is you may have just come into the start of your problems. Okay? Post-termination litigation is prevalent. It's prevalent on a smaller size dollar scale, and sometimes it can really explode. It just really depends on exactly what the nature of the claim is. But leading up to the termination of employment is what we've covered in a real sense so far with the trainings and the manuals. And now this is where your rubber sort of hits the road on if you've done things right, now you're in a good spot. If you've done things wrong, now at termination, you're in a really bad spot. So, the first thing you have to contemplate on a termination of employment is did you have in place some sort of an employment agreement? In other words, was your employment, or was the employee's employment not at will? If you had an employment agreement, you better check that and make sure that you're not binding, or you have not already bound yourself to compensation for this employee going forward, regardless of whether an employee, all right? Hopefully you've got an employee at will if you're going to terminate the employment, and that will terminate your obligations for a lot of the compensation elements. Your termination agreement can include things like a non-compete clause, okay? That would be a provision that survives the employment, and that's something that may be a problem. It may be a problem because your employee says the non-compete's unenforceable for want of consideration, or that it's unreasonable in its geographical scope or time scope. All those are absolute and fair defenses. You may think you've got some protection, and you may be facing a claim to identify that's an employment clause that is not going to survive the termination of employment. The bottom there, COBRA, that's a federal regulation. It's been around for since '86 or so, and you need to know, if you don't already, that benefits are going to continue. So this slide here captures to a real degree what we had covered already, at least in concept. Your best practice as an employer is to cause there to be documentation of what transpired over the course of the employment, okay, and what it is that is the basis for termination, okay? You for sure want to avoid any claim that your termination was for a prohibited purpose or for a prohibited reason, such as race, class, gender, religion. But you also want to make sure that if you have, for example, a misconduct-based termination, that you have this document that you complied with your disciplinary procedures and that the termination was legitimately for cause in the event you come into an unemployment hearing. Unemployment insurance, not an option for employers. It exists for employees as benefit, and they're highly contested. Employers don't like the concept of a fired employee still getting paid, and that payment in a roundabout way counting against an employer. They don't like that. So we commonly represent employers in disputing the unemployment claim. Has anybody in here ever been a part of, on either side, one of these hearings with the administrative law judge?
Not to that point, no.
Okay, not to that point. So you can appreciate, these are kind of weird. They're kind of weird because you as the employer sit in one room, wherever that may be, and you're on the phone, and then the employee is somewhere else on the phone, and you hope the administrative law judge is paying attention, and you hope the administrative law judge hasn't made a decision before you get on the phone, but frankly, I don't know that that's always the case. What's, I think, predominantly strange about the administrative hearing process with unemployment claims is the degree to which credibility can be a deciding factor, particularly and surely when there isn't documentation in place. Cases literally are won or lost based on whether the administrative law judge believes the employee or the employer. And that degree of unpredictability is really, really troubling, for sure, from a lawyer's side, because I can't see the other person speaking. I cannot present questions that cause that other witness to say what I want them to say. They get a free run. Whatever decides to come out of their mouth, they get to say. So that's hard. Documentation, though, okay, takes that part of it out, by and large. We do have here on the slide several points, and we do also have just one more case here that we can try and change up the pace a little and identify. This is Casper versus Federated Mutual. Vince will talk about this one. on what we have as far as the importance of documenting your case.
This is another federal district court case. This is from 2004. And the employer in this case did a good job of documenting the employee's issues over a lengthy period of time. But in addition to that, they had several meetings with her, with supervisors present. It's always good to have witnesses present at these meetings. After many months and several meetings and several warnings, so to speak, the employee finally, said that she just couldn't do a basic task in her job. It was auditing, doing certain audits. And after she could not do that basic task or said she refused to do it, they terminated her. It just so happens that during this process of these review meetings and warnings, that during this time she complained or filed a report with HR that one of her supervisors had sexually harassed someone else. Not her, it was one of her subordinates, but she was filing the report on this other employee's behalf. So 1 year later, when she's terminated, she hires an attorney and makes the claim that her termination was a retaliation. To make what's called a prima facie retaliation case, you need to establish three items. Number one, that you engage in a statutorily protected conduct, that you suffered an adverse employment action, and that the adverse action was causally related to the statutorily protected conduct. In this case, the court found the first two prongs, that reporting sexual harassment is a statutorily protected conduct. And the second prong, she did suffer an adverse employment action. That's termination, of course. But they didn't find number three. Prong three is that it was causally connected. The fact she reported, or she claims that the termination was retaliatory 1 year later after she made the report, was insufficient to show that causation. So the court dismissed the employee's claim on summary judgment, which means at the very early stage, before it ever gets to a jury, the judge tossed it out. So this is an example of where the employer did a good job of documenting, having meetings, and an illustration that employers don't always lose.
So we don't pretend, from our side that federal litigation, getting you out on summary judgment, is cheap. I mean, a federal summary judgment hearing in and of itself, just for that specific hearing, is almost certainly no less than $5,000. Between the time you've put into the memorandum, the affidavits, the submissions, and all that sort of thing, you're into a really, really big price tag. But imagine if you had to go further, it would only be worse. And we also don't want to pretend in any sense that an unemployment claim is anywhere close to the complexity or breadth of a federal lawsuit. But they do have some fundamental similarities in that documents win. Documents win over conflicting testimony. And right now the microphone clip's winning because it won't go in. All right, I'm going to hold it. So keep that in mind. This next slide provides some statutorily scripted elements. Retaliation. Okay. Can't fire someone as a retaliation for any of these, classes of actions. But here are the three prongs that Vince mentioned in this case. And it's really, really notable, both from an employer and an employee side. Just because you complain about something that is a protected complaint doesn't mean you're completely insulated from termination of employment, for sure from the employee side. And the same from an employer side. Just because you have someone who complains about a protected element doesn't mean that employee is on your books forever, okay? You just cannot take an action against an employee because of that protected complaint. Okay. And then a little bit heavier on the legal side of it at the third bullet point, that may help you as an employer, at least as a reference, identify what the characterization is of causation in your employment decision. All right, so in the case that Vince spoke of there, yes, certainly termination is an adverse employment action, but this next slide also identifies what are other things that constitute adverse employment actions. Okay, now some employees may say, I would love it if I had less responsibility. Okay, but by definition, less responsibility is an adverse employment action. Just be careful with what you're doing. Okay, we're close to the time that we have identified, and we're going to start a new topic. And we'll cover part of this topic, but again, if there are questions, certainly you feel free to bring up now or later. Insecurity because of involuntary employment to help them become re-employed. Okay, a couple of provisions there. Involuntary unemployment. If you quit, you don't get paid by the state on the unemployment program. All right. If you're fired for cause, that's not an involuntary unemployment. It is a program that's remedial in nature and must be implied, and this is the standard that employers will face in a hearing, in favor of awarding unemployment benefits. Okay? The premonition is the employee gets benefits unless the employer can overcome that burden. A little legal standard there and preponderance of the evidence, that's really you can consider that that's the lowest burden of proof that exists. Okay, criminal side is your beyond a reasonable doubt, that's the highest. Preponderance of the evidence is your lowest. And this, frankly, here at the last bullet, I just threw that in because, frankly, I wasn't aware of it until I researched it last year, but an employee can be dead and the unemployment benefits are still paid. That I didn't realize. It's obviously not an ongoing benefit, but for the estate planning purposes, something to be aware of. Quitting, as I said, doesn't allow the employee to get the unemployment benefits. Okay, but like almost everything you're going to find in employment law and most law, just because you quit doesn't mean you're not eligible. Okay, if the quit is caused by the employer, the employee can still prevail on unemployment benefits and be eligible and actually get the unemployment benefits. Okay, so if you think that you as an employer just have somebody you don't like and you're just going to make the employment world a problem for them within your walls, and then they'll quit and then you'll be done, well, not so. You can create an involuntary quit that allows the employee to remain eligible for the unemployment benefits. And then there are just some other provisions here that are sort of legal things that you may assert as defenses as an employer against an unemployment claim, or if you're an employee hoping to be able to maintain eligibility for unemployment benefits, you're going to want to look at this and say, okay, I need to steer clear of these sorts of things to be able to preserve my eligibility. And then there's more on the quit. Being laid off, if you're told you're going to be laid off and then you quit, not going to work. And then here you have additional elements at the third bullet point. Just all things that, as an employer, be aware of. And given the time that we have here and now for this presentation, we won't work to go through them in detail, but you all have the slides, and in the event that you're looking at an employee who has quit or that you wish to identify for yourself whether you have any legitimate basis to object to an unemployment claim, you can refer to the slide and then identify if you do have some ammunition. And you can see just from the general nature of how many slides we have on it, the concept of quit is really, really deep. And there are actually, I don't have it on these slides, but there are brand new regulations that take effect that identify an employee's right to refrain from being employed if that employee is taking the time to tend to retired service personnel. All right, if you're a relative of a retired service personnel and that retired service personnel needs personal care, then the employee gets the time off without question. It's not a termination. You can't fire them for it. It's not a quit.
Yeah. I think the last bullet point is probably the most important because some employees erroneously believe that, you know, you can imagine why employees might quit. They may think, you know, my boss makes me show up on time, so it's too rough on me when I didn't show up on time, so I'm quitting. Well, to focus on that last bullet.
And again, the lawyer's favorite word as far as what's reasonable. You're going to fight all day on that. So that kind of carries us through the gist of what we have here. Leaves a few minutes. We've been presenting for, I think, just over an hour. And that's a long time. It's a long time to sit and listen to the thrilling world of employment law, but I didn't see anybody fall asleep, so I'm going to take that as a victory. And I just appreciate your attention. If you have any questions, we'll stick around here afterwards. And then our contact information is also on the slides that were handed out. Thank you.